instruction when it comes to what the Commonwealth must prove with a criminal responsibility issue is not just whether we can say that they don't have a mental disease or defect, because the evidence may show that, but that is not the requirement for the jury. If there is a mental disease or defect, then the Commonwealth has to prove the other two prongs of the criminal responsibility statute. So the way it's phrased in the motion, I'd ask you not adopt that language and that you stick to the model if you were inclined to offer it, but we would object to the giving of it.
Trust me, this won't be the first time that there are arguments about this issue, because ultimately this is what this case is going to be about. It's not a mystery. It's not a whodunit. It's what was going on between her ears at the time that she did it. All right, let's bring in our guest who will be with us this hour as we preview what will be the biggest trial of the summer here on Court TV. Joining us, there he is, folks. Massachusetts attorney. He's a legend up there, Joseph Krowski Jr., but not quite as much a legend as his father. But he's a great, great criminal defense attorney. And also joining us, folks, licensed private investigator Lauren Vellucci, who knows the facts of this case inside out. Great to have you both here. Thank you for being here. Joe, let me start with you. Well, let's clear the air here on the legal standard, because when you talk about what I generally call insanity cases around the country, Court TV, we cover all the states here. Every state is a little different in the way they deal with this. So let us know exactly what the legal standard is for Massachusetts' version of insanity, which is this lack of criminal responsibility. What is the state of mind that takes someone who kills her children with her own hands and subsequently makes her not responsible for that?
Sure. So Massachusetts is a minority jurisdiction in this regard. Most states and the federal standard requires the defendant to prove, and the applicable standard is usually by a preponderance of the evidence or clear and convincing evidence that the defendant was lacking criminal responsibility. In Massachusetts, once the issue is credibly raised, and it can be raised through expert testimony, it can be raised in cross-examination during the government's case in chief, it can be raised through other extrinsic evidence. Once it's credibly raised, the burden is absolutely unequivocally on the Commonwealth, the prosecutor, to prove beyond a reasonable doubt that the defendant was acting criminally responsible. And here's the distinction in Massachusetts. You have to show that the defendant, again, has no burden. But if it's established that the defendant has a mental disease and defect, then the government has to show two things. One, that they could appreciate the law and they could appreciate the wrongdoing. And two, that they could conform themselves to the law. So there's two prongs here. One, the defendant didn't appreciate the wrongfulness or the illegality of their conduct. But two, even if they did, they couldn't conform themselves to that and couldn't conform themselves to the law.
You know, it's interesting, as you explain that extremely clearly, right, just like you do in a courtroom, what that does, Massachusetts, it's actually a little bit easier. It's never easy, but a little bit easier for the defense in a case where you're raising this issue, because it's not just, oh, do you know the difference between right and wrong? It's also, can you comport yourself? Like, do you have that impulse that you have to do this thing, even if you know it's wrong? That's fascinating.
Sure.
Go ahead.
Sure, just quickly. Yeah, I mean, to put it even in layperson's terms, they have to prove beyond a reasonable doubt that the person appreciated the wrongfulness of their conduct. And even if they did, they could stop themselves from doing what they did. That's as basic as I can put it for the layperson.
Yeah, and it's a much different standard. Lauren Vellucci, you've taken a look at this case. You've gone through all of the motions, the papers, everything. Talk to me about what was going on in her life, and why is it that this woman was in the state of mind that she was in? Like, how much of a documented history is there here for Lindsay Clancy?
Yeah, talk about a case file. She has so much documented history and so much going on. She has a postpartum history with the two children previous, but then this youngest child, it was on another level. And that's the thing that is so common and yet so not talked about with people who suffer from postpartum is that it is a different journey for each individual person. And the things that she was experiencing was no sleeping, also a cocktail of all sorts of medication that, in my opinion, is a real problem. They were switching medication so frequently, and she has a documented history of not only seeking help, but seeking help multiple times and telling people like her husband, her mother, multiple doctors. They knew what was going on, and she was begging for help.
You know, Joe, one thing I think is going to happen in this courtroom, and you know this defense attorney better than all of us, Kevin Reddington, another one of the Massachusetts legends up there. I think they can point the finger at the condition, they can point the finger at the treating physicians, and point the finger at the medication.
And the husband, for that matter, even though he's on her side. Look, this is a clear case of the system failing Mrs. Clancy in this case. This is not some recent contrivance. She has the documented history through all 3 pregnancies and births of postpartum depression. You know, maternal filicide cases are very difficult. One of the things I think you actually need to carry the day and move the needle is a legitimate documented history, so jurors don't think it's just a recent contrivance or some kind of a defense that was made out of whole cloth by the defense attorney. So right out of the gate, she starts with that, with the actual findings from her treating providers that she was suffering from a mental disease or defect. If she hadn't been, they would not have prescribed her the medication. Unfortunately, they were unfettered in doing so and completely overprescribed her. The other thing that's really compelling from the legal standard is, again, this isn't her seeking help 6 months, a year, 2 years prior. This is fairly contemporaneous to the actual deaths of the 3 children.
Yeah, and much more so than I think any case I've ever seen involving this, including cases like Andrea Yates, where, yeah, there was a history, but this is next level kind of stuff and very specific. Lauren, what are your thoughts about the husband and what do you see his role being in this trial? Because we've been told he is testifying.
Yeah, he is. And what a powerful witness that will be. He will completely command that courtroom. He is essentially going to be speaking on her behalf. Now, I don't know what their game plan is, but I would be shocked if she took the stand. So he is going to have such a vital role. And he saw firsthand, day in, day out, what she was going through. And he, too, contacted doctors when anything wasn't right with this said medication. And so he plays a huge part. To Joseph's point, he also left her. Now, that is not something I hope he does not feel sorry for. This is a very tricky situation, but he did, in fact, leave her with those children, even for just a little while. So he is a huge witness and a huge part of this case, but his support will also, I think, go very far with the jury.
All right, our guests are staying with us this hour as we get you ready for the biggest trial of the summer, Massachusetts versus Lindsay Clancy. When we come back, let's talk about the jury.